A new practice group we're developing here at Friedman Ranzenhofer is an employee misclassification class action practice. What happens usually with truck drivers or delivery drivers is companies will say, here's an opportunity for you to be your own boss and own your own route. But really that's not what happens. The company exercises control, and there's several factors under New York state and federal law which dictate who's an employee and who is not an employee. New York recently enacted something called the ABC test for motor carriers and transportation delivery workers. And that sets forth multiple prongs of what makes someone not an employee. And there's a presumption, if you're hired as an independent contractor for one of these companies, that you are an employer, that you are actually an employee. Now, we really like this area of law because it allows us to help workers and really take care of people who have been wronged. What we see most of the time is that misclassified employees will end up making less money than they did before they bought their route. So it's like a be your own boss situation, except you have to pay the company, $20 a week to keep your truck washed. You have to pay for your scanner. We're going to make you wait for 4 hours while we load your truck, and you can't bill us for that time. There's all these different little control elements. So these people are people who have worked for companies for years and years, been their own boss, done everything right, and really gotten screwed and not made a lot of money doing that. When we file these cases, the law dictates that those misclassified employees are entitled to double damages under a liquidated damage provision if the violation was willful. So if we can prove that the employer knowingly misclassified their employees, you get twice what your salary should have been. And it really gives us an opportunity here to help workers who have been misclassified. And that's a practice group we're very excited about.